Welcome to another edition of the Litigation Psychology Podcast, brought to you by Courtroom Sciences, Inc. I am Dr. Steve Wood, and joining me today is Baxter Drennon, attorney out of Little Rock for Hall, Booth, and Smith. Baxter, how are you? Thanks for joining the podcast.
I'm doing great. Glad to be here. A little starstruck after listening to 100 episodes of your podcast. I'm excited to be on.
Yeah, and it's funny how you even ended up coming to be on, right? As you had contacted me about something else, and we were talking, and we'll get to it later. But you had mentioned something about training and talking more about training. So I said, you know what, I'm gonna have you on. So
Yeah,
I'm glad you could join. Give us a little bit of background into what your area of expertise is, your area of defense work, and how all the different aspects that you work on.
sure. So I started practicing in 2010. Grew up in Arkansas. Went to college and law school in Arkansas, and knew that as I started my practice, I wanted to be in Arkansas. I worked for I guess almost 11 years at a 70 lawyer firm here in the state. And then in October, made the transition to Hall, Booth, Smith, firm with about 320 lawyers, 12 states. But in my second or third year of practice, I got asked to come with a senior partner in the firm to help him try a case. He couldn't hear very well, and he asked me if I would come be his ears and let him know when he should object to testimony. And that was my first time of really seeing a trial and how it unfolded, and fell in love with that. And I've tried to study good trial lawyers, how to be a better trial lawyer, worked hard at it from there, and have been lucky to try cases since then. And that's a long way of saying I do products work, transportation work, commercial litigation work, but a lot of if a trial is anticipated, I get asked, or I ask to get brought in on the case in hopes of getting back in the courtroom and trying the case.
I think it's a good point, actually, that you said you ask or you try to get in. And I think one of the things we see a lot with younger attorneys, and I say, 10, 15-year type attorneys, not, first, second year, but they're not trying a lot of cases. But you seem like, I think you've tried a lot of cases, haven't you, in comparison to maybe some of your other colleagues or some of the other people who are similar in your time in the being an attorney?
Yeah, so I keep a count based on the ABOTA definition of a trial and lead counsel, and I've been lead counsel in 12 cases, kind of second chaired another 5 or 6, and those are all that have gone to a jury verdict. Then I've got a few more where we got directed verdicts along there. So around 20 first or second chair trials total.
Excellent. And, all of those, you laid out kind of how you have a various areas that you actually work in. Have you found any of those areas more difficult to defend, than another area, or easier to defend than another area, or do you see them pretty similar across the board?
I think transportation cases, so 18-wheeler accidents, I think those are hard to defend for a number of reasons. Generally the public doesn't love 18-wheelers, although during the pandemic we've all seen the importance of them, but there seems to be a bias against them. Usually the drivers have moved on from the trucking company that's been sued, and so tracking them down and working with them can sometimes be difficult. And the facts are typically against us. They're usually cases where we did cause an accident, or we don't have a way to prove that we didn't cause the accident. And I think if you can't prove you didn't do it, you're in trouble on a liability defense with a trucking company. So for those reasons, I think those are harder to defend. In my experience, products cases with a manufacturer, you usually have a manufacturer that's engaged, that has worked hard to design and manufacture a product to the best of what's available scientifically. And I don't know if they're easier to defend, but certainly easier to work with the company to create a defense with those.
Yeah, I think, one of the things we do a lot of work with trucking companies and stuff too, and that's one of our, areas that we really like to focus on. Have you noticed any change? I know prior to, obviously, a lot of people had negative opinions towards the trucking industry. The pandemic hit, and then people started to increase their perceptions because they were the ones bringing your goods and stuff. Have you seen, at least personally, any shift going back towards that negative opinion that people have of truck drivers, or do you think it has it stayed consistent from pandemic where they've actually gained some ground and it stayed?
I haven't tried a trucking case since the pandemic started, but the verdicts that I'm seeing would suggest that they are not getting the benefit of the pandemic, the focus or importance that was placed on truck drivers during that time period. I think that's probably at a macro level, we all see and understand their importance, but when we get into a jury trial and 12 folks there, I think the bias against them is probably still there.
Yeah, and I think one of the things, right, is a lot of times people have had bad experiences with the truck driver, whether it be on the highway where maybe they got over in front of you, or they're in the left lane while you're trying to pass, or anything. Everybody has their own kind of horror story of sorts with truck drivers. So I can see where that has still kept going forward even post pandemic, which hopefully, as we've talked multiple times on the podcast, that we want to get over that and hopefully try to raise up the trucking industry.
Absolutely.
And I want to, one of the things you talked about, you tried several cases, and I know that you've had some defense verdicts. You've been successful in that. Do you have any defense verdicts that you found that were, your favorite or your proudest ones that were, it was kind of like the quintessential win for you that you can remember and look back on?
Sure, a few. One's funny, so I'll tell it. That first case I was talking about, where I carried the briefcase, we got a defense verdict in it, and I was proud of it. The firm I was at was Wright, Lindsay and Jennings, and the Jennings of the firm, his son is who I tried the case with. So that was special just from that perspective. But I learned a lot. I learned that in that case, the facts matter, but also how, as lawyers, we present ourselves matter. After the trial, we got an email from one of the jurors that to Mr. Jennings and I, that said how much she appreciated that we had gotten our haircut. That the plaintiff's lawyer had not gotten a haircut, and he looked sloppy, and she didn't believe him because of that. And that's something that's always stuck with me when I talk to young lawyers about trying cases. That's a lesson I've learned. The way you present yourself is as important as the facts, is as important as the law. And so that one's special to me. A couple of years ago, right before the pandemic, we had a multi-week products case that we got a directed verdict right before closing arguments. The judge let us go to closings and gave us a directed verdict. And that was exciting. It was a huge case, but maybe more exciting for me is I turned around and the next day started another trial, and I got I was going to say a full defense verdict. That's not true. The jury awarded $87 to the plaintiff. And so doing them back to back, and just the frenetic energy that came from doing that was really exciting. But it's always fun to get to try a case. It's always some pressure and stress. But I would say that anyone where I had a client tell me this: anytime you leave without paying millions of dollars, it's always a good day in the courtroom. And so I've had a lot of those good days.
Yeah, I think you said a couple good things in there. The first, as we've had conversations offline before about attorney credibility and stuff, I'm a strong proponent on the idea that, to what you just said, that it's not necessarily, just what you're saying, but it's also how you're saying it, how you're presenting it. And I think there are some attorneys out there who just don't put a lot of stock in perceptions of how jurors are going to perceive them. They think the case facts are going to carry the day, and whether or not how they present it, or whether or not how they're dressed, or how they interact with witnesses doesn't matter, right? They just think whatever, the evidence will carry the day. So I'm glad that you brought that up and pinpointed on that. The other thing too is one of the things you said about, as long as you get out of there without paying millions of dollars, that's another thing too, right? Is when we talk about defense verdicts, sometimes people will think it has to be a $0 verdict, but that's not necessarily true, right? I mean, you could have what you refer to kind of as a defense win, where you actually have to pay some money.
Absolutely. And I think this idea that if you can't get a zero in a case, you shouldn't try it, is something that's kind of hurting the defense side of cases, the industry or the insurance side. That if there's any risk of a verdict above a zero, we're not trying those cases. We're scared to try those cases, and instead, I think we have to look at them, evaluate them honestly, and stick to our number and our evaluation. And even if that's there is a dollar figure associated with it, be prepared to go to trial on that case. And if you beat your dollar figure, then I consider that a win. Certainly, if you beat what you can settle it for, that's a win. But the idea that you have to get a zero or you shouldn't try the case, I think is hurting us.
Right. And I think that's another thing too, is we're not applauding these defense wins that are, it's all, everybody's focused on the 0, 0, 0, but there's times that you should be, like you said, applauding those ones where maybe the ask was 10 million and you ended up taking it to trial and it was 2 million. I mean, that's ultimately a win as well. And I know you have you actually got your hands in a lot of things, right? As far as with DRI and sitting on advisory boards and all of those other things. What kind of is your feel from the defense bar as far as whether or not the defense bar is looking to take cases to trial more, or is that kind of the idea of let's just settle? Is that going away and let's say, you know what, let's take it to trial. Let's go against the plaintiff.
I think it's less about the bar as a whole and more about firms, and probably even down to clients and lawyers. There's an aspect of the industry that wants to resolve cases as quickly and cheaply as possible, without a lot of effort from the defense lawyer to defend the case, if that makes sense. And so I've seen what I think is an attitude of we don't want to win anymore. We want to resolve it and move on, as opposed to putting out what I see as an all-out effort to win the case. Winning a trial is not a half measure. You have to go all out. And from my perspective, I think there are some clients that are seeing a change where they are willing to do that. And I think law firms, particularly like Hall Booth Smith, are interested in coming to agreements with clients to where that's both affordable and doable. There's a disconnect between clients and lawyers. Lawyers want to bill hours and clients want to pay less, and going to trial costs money. And so I think as we continue the practice of law on the defense side continues to develop, we're going to see more arrangements that put us on the same side. So reverse contingency fees, flat rates where you're rewarded for winning a trial, taking a case to trial and winning. But until that's widespread across the board adopted, I think we're going to continue to see this attitude of resolve the case cheaply, quickly, with as little effort from defense lawyers possible.
You said something that was interesting. You talked about reverse contingencies, and I've heard some people start to talk about that. Is that something that's actually becoming more prevalent, or something that in the defense bar is something that's actually gaining traction that people are talking more about?
For some people, they've been able to get them instituted and have done well with them. For me, I have not had a client agree to it yet, but it's something that was not in the conversation before, but now we can at least, start the conversation. Certainly more advanced than that are the flat rate fee agreements. Again, where the client knows what they're going to pay. The defense lawyer is given free range to do what it takes to win the case. And I'm talking about from an hours and effort perspective, not from an ethics perspective. And I am seeing those much more widely adopted. And I think the clients that understand that they can't just write checks will continue to adopt, one or both of those models.
Interesting. Yeah, I'll be interested to see how that goes going forward, because that seems to be, at least from my understanding, one of the newer things that people have been talking about. I want to switch gears a little bit and talk. As you said, you're an Arkansas guy, graduate school, Arkansas, and all of that. What's kind of the legal landscape right now in Arkansas as it relates to COVID? I feel like I'm kind of nervous that we're going to go back to 2020 here. I've had several cases that I've been working on get bumped to later on because of concerns about COVID. But what's the lay of the land there in Arkansas?
Sure. Arkansas is a red state. We've had, I'd say, some of the most conservative rules related to COVID in the country. Pulaski County, which is where Little Rock is, the capital, through all of 20, or after COVID hit, and a substantial portion of 21 was not open to the public. Excuse me. And so it has opened up. Other than Pulaski County, you might have had some here or there that were closed, but largely the courts remained open. I tried 3 cases, March of 20, August of 20, and then last year, early 21, where, we were able to try cases through COVID. In the last 2 to 3 weeks, we're starting to see shutdowns again. One of our federal district courts has continued all but the absolute necessary trials and in-person hearings. And so I'm like you, I'm afraid that we're going to shut back down, hopeful that Omicron goes away as quickly as it came, and maybe we won't have that.
Yeah. Have you had to do much over Zoom? Any sort of probably not Zoom trials, but Zoom hearings or anything as it relates to that?
Yeah, we did a ton of Zoom depositions, which for certain fact witness depositions at this point, I'd rather have it by Zoom. There's a substantial time savings, and for the right witnesses, I don't think there's a difference between the Zoom or in person. I've done a multi-day TRO hearing via Zoom. We had hundreds of exhibits, and it was awful.
Yeah.
There were 3 different sets of attorneys. There were at least 4 rooms with the judge or the court, via Zoom. And it just, with that many people involved, somebody's computer messes up, 10-15% of the time. And it really was bad. I don't think the court was able to see and take in all the information in the same way that we would have been able to do it live. And I don't think we were able to present it in the same way that we would have been able to do live. And it led to an outcome that was not ideal for my client. It ultimately worked out, but I think the Zoom hearing really limited what we could do. I can't imagine trying a case via Zoom. Certainly not something that was significant, unless it was, my client's absolute insistence. I would recommend against it.
Yeah, I think that seems to be kind of the feeling I've gotten from a lot of people. There's the convenience of it, but at the same time, there's all these other technological issues, and then just the fear of, could you imagine if you had a $20-30 million case that rested on whether or not the guy who was watching was paying attention, or he's chomping on his bag of Doritos and drinking his Pepsi in the middle of it, not paying attention and playing on his phone. I would be terrified as a client to have to think that that's the way it'd be resting on those people who are not paying attention.
Absolutely. And you would probably know this better than me. And attention spans continue to decrease, and that's live and in person. I'm not sure. I'm sure somebody's done a study on attention span between the screen and in person, but I suspect it's even lower or less time. And so you're right. The number of distractions that a trial lawyer has to compete with when they're talking to a juror in person are heavy enough. I can't imagine exponentially more via Zoom. So I don't think that's a good way for our system long term to continue. Again, at least not as to significant trials.
I agree. And so I kind of want to wrap up talking about training, because like I said, this is where you and I had our initial conversations with one another. You had mentioned that a lot of things that you've done yourself to try to go out and get training. And a lot of times on the podcast, we've talked about training that needs to be done for the defense bar. Kind of what is your thoughts? If you had kind of a laundry list of things that if you could get training on, what would it be that you feel like would be something that'd be very valuable for attorneys to learn?
Sure. So I was very fortunate. My first firm sent me to deposition school as soon as I started. Went to trial school a couple years in, and those were both NETA programs, and they were excellent. First, maybe beyond a 101 type class for both of those things, but certainly not advanced. Um, I, if you're serious about trying cases, I think uh, witness prep is a really in-depth witness prep. I mean, listen to you all on the podcast, learn the psychology that comes with answering questions as a witness and being able to prepare witnesses to deal with that. I know reptile theories shifted to the Keenan Trial Institute, but those questions were effective because they created cognitive dissonance for witnesses. And I'm a trial lawyer that has a political science degree. I don't know those type skills. So I think classes on that, learning that, and that witness prep's not just for sitting in front of the jury. That's for depositions. And so there, I think, I don't know if it's as much a class as it is just continued practice. I think at some point, DRI or some other organization is going to start putting together skills competitions or skills training where lawyers that are 35 years, 45 years, maybe 50 are given an opportunity to practice their skills in front of others. You may see some of that internally. I know of a firm that has an internal trial competition where annually lawyers participate in the trial competition. But I think you're going to have to see some of those type things because even the most productive trial lawyers, 2-3 trials a year is about the best you can ask for. And I don't know if that's enough to keep up with the advancement on the plaintiff side. We want to complain about reptile theory or whatever the new theory is, but I think that's certainly an issue. But the fact that skilled plaintiffs lawyers are working hard to improve their craft is as big an issue or more. And we've got to be doing the same thing. As you know, to do that in Arkansas, I'm fortunate to be the president of the Arkansas Association Defense Council. So for our seminar this year, we're going to have presentations on these hard issues. Arguing damages, I think is a great place. Obviously, we're going to have training on witness prep and even bringing people in to get a first level witness preparation training when there's not the pressure of a case that's pending. But I think I'm not sure there's a topic that should be off limits or that shouldn't be covered in terms of training. If we want to be able to continue to try cases, we're going to have to win those cases that we take to trial, or at least a substantial portion of them, so that we continue to be trusted to do it. And if it touches on that, whether it's psychology, from I'm not sure what you call acting, blocking, how you move, how you present yourself. I just don't think there's an aspect of that we don't need to perfect so that we can keep trying cases.
Excellent. Yeah, no, I think you bring up a lot of good points that, the training that's needed. And then a lot of times it's just putting yourself out there, right? And feeling comfortable to say, okay, there's this gap of knowledge that I don't have, or feeling comfortable getting up in front of a group of people and, doing like a mock opening statement and having to put yourself out there. So I think all that's all good. And hopefully, like I said, that people will take you up on that and listen to you and start enacting more of that training and spread that out through the defense bar. Baxter, I appreciate you coming on. If anybody wants to get a hold of you for anything, any questions, any potential work, how do they get a hold of you?
Yeah, well, the Hall Booth Smith website's a perfect place. My email address is bdrennon@hallboothsmith.com. Phone number 501-319-6996. And I'd love to talk to them about any of this or more.
Sounds good. Well, Baxter, like I said, I appreciate you coming on. If you have any more information, if you'd like to contact me, I can be reached at swood@courtroomsciences.com. As always, our blogs, podcasts can be found at courtroomsciences.com. This has been another edition of the Litigation Psychology Podcast brought to you by Courtroom Sciences, Inc. Thank you.